We are on section 11 of remedies, and we're nearing, I'm sorry, section 10. Probably scared you all to death. And we are dealing with a topic called special relief for families. And there are a number of different issues in this regard, and some of the things we touched on last week as well. This is the only class for this week. What would normally be Thursdays, we posted online an assignment that we said at the outset you would have to do, which is to draft a complaint. The facts are there. There's some checklists there for you to look at. So Thursday, instead of coming to class, or you come to class and write it, but you have to prepare the complaint from the information that's on file and submit it to me so that we can look at it. So whether you're online or in class on Thursday, your assignment is to do that complaint with the information that's listed there and have it in a form suitable that it could be filed in court. So take a look at the stuff. I think you'll find it's interesting. We have a couple of rules to worry about today, and they're rules that are little known until you have a problem. So I want to just touch base on them quickly. But they're rules 5 and 6. A lot of times when you get served with a motion, you look at it and say, okay, well, I've got to respond to it. And the question oftentimes comes, well, how long do I have to respond? And that can be both a function of the motion itself, what type of motion it is, but it's also a function of both the local rules and the rules of procedure. And rules 5 and 6 help to tell us what we're supposed to be doing there, because it talks about computing the time to respond and the like, and whether we need to use the intervening weekends and what counts as a business day, whether we're even counting business days. So when you've got that motion to respond to and you don't quite know how much time you actually have, whether you're going to lose the weekend or not, because you've got to work, then you're going to look at the provisions of those rules to see exactly how you compute the time. First, Rule 5 deals with serving and filing pleadings and other papers. Once a party is represented, you don't continue to provide them the information through notices and the like. You provide their counsel the notice, whether it's a discovery motion or a memo or something like that. Again, Rule 5 sort of leaves to specifics how you would go about serving that person. Usually first-class mail is still the preferred route for serving opposing counsel, but there are times where maybe you want to serve opposing counsel in hand as opposed to by mail, because when things are done by mail, there's usually an additional period to respond, so maybe you want to advance it a little faster. But if you look at the means of service, when the party is either represented or if they're not represented, how you would provide them this information. Rule 5 is going to talk about how that is done. And again, just to point out, when you're in federal court now, virtually everything is filed electronically. And then notice is then sent. The copies are sent electronically with the push of a button. So you have virtually instantaneous notice of what's been filed. And at times it might be unfortunate, but you also have instantaneous receipt of what's been filed. And so your clock may start running a lot sooner than you may like. But that's the process in the federal court. If you don't have rudimentary computer skills, you need to have them. Because even if you say, well, I don't want to practice in federal court, you don't control exclusively whether your cases are heard in state court. You remember that the other side has a right to remove it. And so if you don't decide to acquire those skills, you need to make sure you have someone who's capable of it, because everything in the federal court is really done electronically now. And it's good because there's an awful huge database of information out there that you can access. It makes the whole idea about assembling multiple copies and then making sure every copy is the same and sending them out, makes that process a lot simpler. But it does require some level of understanding about, how to turn a Word document into a PDF, and then how to make sure it's properly filed, and then make sure that the notice goes to those people that have it. So again, that, at least in part, is covered by Rule 5, but also recognize that the local rules of court in the federal court may cover some of that, the times of filing and how that works as well. Rule 6 is simply, in its title, Computing and Extending Time for Motion Papers. And I know this, it sounds insignificant, the title is insignificant, but there are lawyers that like to serve things on a Friday afternoon, and there are other lawyers that, back when the fax machine was the big deal, would turn off their faxes on Friday afternoon so they couldn't possibly get receipt of that information. Problem now is you may have it electronically by email. And the question, does that count then? And how do I start computing it? And so the problem is you're virtually never detached from some method of providing at least a view of whatever the information is. I want to stop short of calling it notice, because I think there's a proper way to give notice, and you need to look at Rules 5 and 6 to make sure that complies, because I don't intend to work the weekend if I don't have to. There will be times where I don't have a choice because of the crunch of time and how little time I have to respond to it. But I'm not going to play into the fact of you trying to make my life miserable simply to gain some type of tactical advantage if you screw up and don't comply with the rules with respect to proper notice and the like. And then the computation of time. And again, is a practical matter in the real world, how we compute what 10 days means as opposed to 14 days matters. Frankly, there are times where, when you look within Rule 6, some of the motions that you have 10 days to respond to, you would actually potentially have more time to respond to that type of motion than a 14-day. Because 14 days will count the intervening weekends, the 10 days may not. The 10 days may give you virtually the same, if not a little more time, if there's a holiday in there and the like. So you don't need to remember this for anything other than down the road when you've got these papers and you say, well, how long do I have to respond? You're going to find some of that information in Rule 6 and some of it within the local rule. And that becomes important, because that's going to matter as to how much of your weekends and nights you might be giving up when you've got a case that's burning hot like that. And some people do it for tactical advantage. It's unfortunate. But there are times, by the way, where, because of speed and the like, I need to serve you on Friday. I don't want to wait till another week, and then that really would potentially means, with the notice provisions, that we're bumping out a whole extra week just because I couldn't get it out of the office by Friday. If I get it out of the office by Friday, that might mean, in essence, that we get heard a week earlier. And sometimes, and especially, by the way, with some of the issues we're talking about today, the family law issues, even more than a lot of the other cases we deal with, at least the litigants feel that this is an absolute emergency house on fire situation, and so days start to make a difference with respect to what it is you're asking and whether those things should be allowed. So when you get a chance, take a look at Rule 5 and 6. I'm not going to test on it. I just think there are little-known rules that you should be aware of, and what I can tell you from a practice standpoint, they become really important when you're trying to figure out whether you're working the weekend or not. And I work weekends. If I have to do that, that's what I have to do. But If I can get Saturday and Sunday off and put it off to begin the first of the week, that's good too. So look at it, and because they do become important. And here's the last part of it that becomes important. You know, sometimes people say, well, I'll just call the clerk and see how long I have to respond. They're not always accurate. That's the first thing. And so the fact that the clerk told you isn't going to save your butt if you miss the deadline. At least they may well disavow that they told you that anyway. But B, it again is a level of professionalism to make sure that your papers are filed timely, and that you're not always the person coming into court with an excuse as to why you didn't make the deadline, or why you didn't understand the rule and thought you were within the deadline. Because at the end of the day, your reputation becomes you're not the person who does things when they're supposed to be done. And to me, from a professionalism and a practice standpoint, I just don't get that. There's no excuse for not being where you're supposed to be, prepared to do what you're supposed to do in our business. And that's 90% of what we do. And it doesn't take a lot. If you do that, unfortunately, you will stand out, because there's an awful lot of people that are already in our profession that aren't prepared to do what they're supposed to do when it comes time to do it. And so to me, it's a relatively easy thing to appear more professional simply by meeting the time standards that you're supposed to do things. And then when you are providing the notice and you're on the other end of providing that information to the other side, to make sure that you've done it sufficiently timely and professionally, that it's clear that the rules are being followed. And I can't stress this enough. If you guys are going to litigate cases, if you're going to do, especially civil cases, which have a lot more rules than the criminal cases, but the criminal cases, the rules apply as well, then read the rules. Right? You wouldn't play cards if you didn't know the rules. And when I say read the rules, I mean like you would study them and understand them like you were playing cards, right? Well, I don't keep asking how many cards I can draw for playing poker. I don't ask how many more cards I get in 7-card stud if that's what we're playing. I can do the count. I don't have to appear that I don't know what we're doing. And the same thing happens here. There's a lot of people, again, that are lazy, that don't want to look. And so Lewis won't give me my extension. Okay, now really, that's unprofessional. I just needed a week. It wasn't like I was, out having a party. I've got other work. I need an extension. He won't give it to me. And by the way, there are times where you can't give them to him. The client needs to go in. It's an important matter. I would, but I can't. I'll talk and try and see. But he might just be doing it because he's a jerk. Okay. So what does the rule say about me requesting extra time? How do I go about doing that? And I will do it. But I'm going to know how to do it before I ask Lewis and he says no. Because I'm going to tell him, if you do that, then I'm going to file a motion with the court. I'm going to request 2 extra weeks, and I'm going to tell them that I tried to conference this with you and you said no. And that's okay, you can say no. But that's the first thing the court's going to ask me when I go in is, did you ask the other side for an extension? I did, Your Honor, and they said no. Okay, and maybe you're right on no. Maybe you're right as to why it's unreasonable. But I'm going to know from the rules how I can get what I want. And I'll try and get a little more, since you're going to make me have to work for it anyway. But I need to know what this provides, what the rules provide in order to do that. And I really can't stress that enough, whether it's the rules on deposition, what happens when you think someone's abusing the process, what your rights are, all of that. There's not really that many rules if you're going to make civil litigation your life. You should understand how they relate to one another, and for every action, what the permissible reaction is within the rules. And it doesn't get very complicated, and you'll be surprised again how many people don't understand them well enough but want to play a big game of bravado and bully and all the rest of it. And like every other bully, they back down when confronted with an equal amount of force from the other side. So the force for us is within our rules. Questions on 5 or 6 yet?
What is your take on filing via email to opposing counsel? Or does it depend on what is being said?
Well, first of all, if I'm in federal court, it's an electronic filing. When I hit the button, Lewis gets it virtually the same time as the court does, so I don't even have to worry about that. And when we're in state court, I think it's still mailing. I don't think, and first of all, the rules, as a general matter, are going to require the mailing. So I just don't think it's necessary. If I give you the email notice, that only gives you additional time to then prepare and respond. It could be a courtesy, if you want to do it as a courtesy. It doesn't necessarily gain you an advantage. And to me, listen, I've practiced law for 30 years now. I'm a lot older than all of you. I still think that there's real value in paper in our business. And I know that's sort of anachronistic, but this new thing for all the real estate transactions, for any of you involved, it's all electronic signing now, and there's a dot loop and a couple of others. I still like to look at the page. I like to see what it says, and I like to make sure it says what I think it says, because it's not. My he's got a freaking iPad the other day. He showed me something about this size for the PNS. I saying, God damn, can't you print it or something? Can you put it on my iPad so I might be able to see it? And frankly, I worry that in our business we're dotting your I's and crossing your T's and being fastidious about detail, and especially when you're dealing with hundreds of thousands of dollars, it matters. And so I still like to see it. Now, a short email, that's a completely different thing, but when you're in the same type of thing, I'm supposed to read a motion in a 20-page memo all on my computer screen. Where do I make my damn notes? You know what I mean? Like, where do I say, oh, go get this or this? And I know that, I know that many of you probably do it very differently, but I still like to put pen to paper. And then it helps me to look at it, to turn it, and to figure out where things are and how they relate to one another. So, to me, if you send me an email, I'm going to print it out anyway, because I want to hold the paper. And I know, by the way, that it's wasteful. And I have way too much paper in my office at any given time, especially when you get cases, because, you print it off, and all of a sudden you got crap everywhere. But I still use it, and to me, it's an additional value. Part of it is, I think, simply because I see better the black printing on the white paper on here than on the computer screen. Plus, it's more permanent to make my notes and everything else. But you guys should do what works for you. But again, our business, dotting the I's properly and crossing the T's, is what can make the difference between winning and losing. So you want to be careful with that. And the last part of that, I don't want to make this sound that your experience in the adversarial system with litigation means that Lewis and I have to be adversaries. We can get along. We can do things appropriately and not necessarily take it personally with respect to whether what the clients are experiencing, and that should be the way it works. There will be times where the other attorney is not as cooperative and not as professional, and you still can't let it affect you and start to do some of these sort of little nickel and dime things that some of them do, just to sort of try to gain a little bit of a tactical advantage or to aggravate you, because then your reputation is tied up with it. I always remember I had this case against a big firm, and I called and I asked for an extension. I needed 10 days. I wasn't asking for a month or 2 months or anything like that. And she said no. It really was a big firm, but my experience is the big firms are always jerks. Always. Because they can hide behind the big firm. When you call Mike Coyne asking for an extension, I can't say, well, the boss says no, because, and you know, and it was early on in the case, you know there's going to be another day here. And so I don't know whether it was 2 months, 3 months, 4 months, but then she called needing an extension, of course. And by the way, okay, you said no, so all I did was file a request with the court saying, explaining, we just got served 2 days ago, we've got to do X, Y, or Z. I asked counsel for an extension, she said no, I need 10 days, or I need 2 weeks, whatever the hell. I probably asked for extra time now, simply because you aggravated me a little bit. So then, I don't know whether it was 3 months, 2 months, 4 months, she had to make the same request. I could have easily said no. But frankly, there's no advantage to saying no, because she's going to do the same thing I didn't get it, and then I look like a jerk, so I'd rather appear magnanimous and get my revenge just by being nicer than she was. And when I reminded her that she had said no when I made the same request, so I at least tried to make her feel bad. But again, I don't think lawyers at big firms feel bad either. But so you got to be careful of that, because what can happen then is the litigation becomes just, every time they call, you don't even want to talk to them. You don't want to pick up the phone because they are just personally repulsive and you can't stomach them. But that's not the way it has to be. I've had cases, a fair amount of cases like that, but I've had a lot of cases where the lawyers get along, and we get along well. We're adversaries, but they're not cheating, they're not doing things that are improper, and then we don't have to do some of these things and try to screw each other out of weekends and just, gain a tactical advantage because we can. And frankly, in the long run, I think it serves you a lot better to be careful like that and to be professional. I know it does. But we have one more thing to discuss before we do our cases, and that's 209As, and those are restraining orders issued by the probate court can issue them, but so can the district court and the like. We oftentimes see them when marriages or the relationship goes bad, such that one is in fear of their safety. And these are orders that require the party who the order is issued against from not having any contact with the other person. And sometimes these are used improperly for tactical advantage. They obviously shouldn't be. They only should be used when the situation is sufficiently meritorious. But there are a lot of times where these orders are absolutely essential, and they give the court the power to issue an injunction against the other person from posing that danger and having to stay away and not having contact with the other person. And technically, those orders are available, and not just technically, those orders are available 24/7. There's always a judge on call if your client should be in fear of their safety and the like, and so you want to look at that for those purposes. Now we've got a few cases that I think are interesting. I hope you found them interesting. But the first one's Burke versus Revo. And so we've all heard of wrongful death cases where because of someone's negligence, someone has lost their life, and now we're bringing suit for the financial losses that occur as a result of that wrongful death. But Burke versus Revo is an interesting one because it's not about wrongful death, it's about wrongful birth. And last section, we saw people take extraordinary and financially very expensive measures in order to have children. But here in this case, these people want to recover for the birth of their healthy child. So I'm wondering first if you have any policy issues with respect to a case like this. I mean, should we allow someone to be able to sue for the birth of a healthy child? Philosophically. Gifty says no. Accept God's gift move on, and if you don't want it, send it out for adoption.
I think you should if the doctor guarantees it won't.
You should be able to sue for wrongful birth if the doctor guarantees that there'll be no further births. So, by the way, you all agree, you do agree with that. You don't think philosophically this raises problems, or socially? You know, because like when we were kids, I'll be honest, we were kind of cruel with one another. I guess you guys grew up being much nicer to one another. You didn't have that, because I could see some kids saying, you know, your mother and father didn't want you so much, they sued when you were born. That type of thing doesn't bother you? That's kind of pretty heavy baggage to carry, no? I mean, because don't you must have siblings, and you always sort of think, oh, mom likes him or her better, you know?
They don't disclose it.
I mean, you don't disclose it. It's in the books for everyone to see. My dad sued. They didn't want you that much. You don't think that that's for psychologically kind of a lot of baggage to carry around, that public policy says, well, this is a bad idea, no?
Yeah, but I mean, like the case said, you'd like to think that everyone thinks having a child is a blessing, but that's not the case.
Okay,
You
so...
take certain steps to prevent that from happening. The doctor guarantees it.
Well, but then, so you don't think your child is a blessing?
Not all people do.
Okay, but so if you're suing, you're thinking this child's not a blessing, it's a curse.
Well, it's
So those are the types of parents we should give money to, I'm sorry, Karen?
I'm sure they love their baby and raise their baby, and this is their fourth child. They obviously made a decision they couldn't afford this child, and they relied upon and took the extreme measures of not just getting the tubes tied and burning the ends, which, by the way, as I'm sure you're aware, doctors like up the wazoo tell you, are you sure, are you sure, are you sure, are you sure? You really don't want to have them burned, because we will never be able to fix this. You will never, ever have a child again.
So the guarantee,
Sounds like a guarantee.
Okay, but so you
That's
didn't,
standard.
but so you don't want the child. Give them away. There's a lot of people that do.
Well, as we already decided, that's, to some people, murder or abandonment. It's unacceptable to their moral fiber. It's just not a choice. It's not a choice. You either have
Wait a
it or
minute,
you don't.
abandonment, and what wasn't their moral fiber, but suing to receive compensation for the birth of the child is within their
but it was negligence.
personal motive.
It's malpractice, right? It's medical malpractice. They said they would perform a particular
Well,
thing and they failed to.
Does anyone disagree that there's a breach of contract or medical malpractice here? No, but I'm with you on that. But so I guess I'm back to, and so there are damages.
But it's not, the term compensation is, I don't think is appropriate, because it's not a business. Have a child is the couple gonna raise the child and gonna spend a lot of money, and also it's gonna be in disadvantage of the other three child, so they can afford it literally another
Well,
child.
but I can afford it if I stick my hand into the pocket of the doctor here, because doctors have lots of money.
Well, it was absolutely extreme.
That's why.
But
Why the doctor have-
if we're going to treat it like a contract, and that's what I'm hearing, some type of compensation for the breach of contract, well, what about that contract principle about mitigate your damages? Give it up. Why, if this is a curse, why shouldn't you give it up to someone who wouldn't see it this way at all? Someone would pay $50,000, $60,000, $100,000.
Why is it being called, what, is it a child here and there's
And you don't want it.
an assumption that this is not a blessing and it's now a
That's what you
curse?
all told me.
I didn't hear that.
I think it's
Oh, wait a minute, you didn't hear that? I thought we said, well, let me ask you that. Does that make a difference whether the parents did this for financial reasons or otherwise? And suppose we said, you know what, we don't want to have more kids. Our first child, there were some genetic issues, the testing, there's such anxiety, we can't go through it again and take that risk. And so they did this, and then lo and behold, healthy child. Do they have damage? They didn't do it for financial reasons. They did it because they were concerned about having to raise an unhealthy child. Well, you just hit the lottery then, didn't you? So do you have a claim still? Does it make a difference whether you did it for financial reasons or other?
the court said yes.
The court said it did make a difference. So I guess we got to lie. We got to say, no, we don't want the kid. No, right? Well, that's what we got to do. That's what you're telling me as my lawyer, would you? Don't say you did it for anything other than financial reasons.
But I don't understand why hold the doctor liable instead of giving away the child, like you said, and having someone else pay the bill who wants a child and willing to pay.
Okay, so what about
Why is that
that?
not an option?
Because we'll just give you the money. Someone would give us $50,000 for this kid. No?
It'd be a little challenging to explain that to their siblings, you know, I'm going to the hospital, but
I mean, a
parents
lot
don't know.
of people, I know 2 guys that had a vasectomy because they already had 3 children, and financially, they weren't able to take care of another child, so they, got a vasectomy, so to ensure that they didn't have a kid. So I think a lot of people do it for that reason.
I understand it completely, but then, so we're not gonna make you obligated to take care of that children. We're gonna find a home that would be happy to take that
Yeah,
child.
but then you're talking about stripping a parent of their fundamental right of having a child.
So you have a fundamental right to have that child, but another fundamental right to stick your hand in Lewis's pocket and make him pay for that child you love.
But you tried to prevent it from financially restraining your family. The doctor said he could help you with that. He didn't. He was negligent. You don't mind actually raising the child. It's just the financial part's the burden.
Oh, well, at least you don't mind raising that child.
Well, things would want to. It's just if you can eliminate the financial burden, I think.
Oh, sure, let's take the money from the doctor.
But that's again, the parents having it both ways. They don't want the child, but we'll take the child if someone else is going to pay the bill.
Yeah, I would have had a lot more if someone else was going to pay the bills on these kids. But into your computation, everything goes? So the doctor owes for what? So let's start. Doctor owes for the time lost to work while she's pregnant.
Yes.
And for whatever the medical bills are with respect to the birth of that child.
Yes.
Yes.
Okay.
College education of the child.
Okay, well, you don't have to skip right to there. Well, no, okay, so let's take our time,
Other
okay?
activities.
So daycare?
Yep.
Yes.
Yeah.
Because I wanted to continue to work. I was established in my career now. So daycare?
But now you need a name.
No, and the nanny, summer camp?
School.
He really likes to go to that Brook summer camp, but it's kind of expensive.
New sneakers.
So wait a minute, summer camp? New sneakers?
Ivy League education.
Well, let's guess you wanted to get, you guys say that there is no limit here? So food? So
The doctor
the
may not.
child's share of, let's say it's 2, let's say 5, we'll use Nick's example, 1/6 of the household expenses are on your dime, Doc. Because there were 5 of us before, now there's 6. Wait a minute though. Because even when I said that, so 1/6 of like the mortgage payment, we need a bigger house, you know.
This is their 4th baby, correct?
So wait a minute though, so these are the damages. We're gonna keep going
It's
here.
very extreme to me.
Private school for high school?
Oh, definitely.
No, seriously, private school for high school?
No,
They're gonna bring
that's not
Well, does it make a difference what the other 3 did?
Yes.
Yes.
Yeah.
Okay, so the other 3 are in private school, this kid gets to go to private school.
Yeah.
What about the other 3 aren't, but they're not as bright? This is our last kid, the last one. Who's the baby in the family here, anyone? No babies in the family? Any oldest children?
Oh, yeah.
Huh? Out of 8, you're the oldest? Oh, wow.
7 brothers.
Oh, really? You're the only girl, too? Oh, wow, that's brutal, huh? My sister, it was 4 brothers, my sister was the oldest, and she would tell you it wasn't easy. So wait a minute though, so even high school? And what about those expensive like soccer and sports camps now, and all of that's on the doctor's dime? And where are you going to draw the line though? Because my understanding is you were saying, but for the doctor's breach of contract and negligence, I wouldn't owe a thing.
Then don't keep the baby, give it to someone who wants it.
Back to Al's point. What about that? You don't want them. You don't want the burden. By the way, I mean, and I hear what Nick said, and I hear what Karen said, but you didn't want them. I mean, it sounds like there's going to be a little resentment no matter what here going forward, no? And someone else would die for this kid. By the way, no, okay. So what about these points? Why shouldn't you?
So all of a sudden it becomes
Have to
okay if
mitigate your
somebody
damages.
else pays for it. If somebody else pays for it, it sort of becomes okay.
Yeah, but
So you want the child, but now.
I didn't read that they didn't want the child. They're just read it that they didn't want it because of financial.
No, and that is, you already said that, and I think you're correct, that the court made a distinction, right? If it's financial reasons, and you are then stuck with the financial obligation, then you do have a pocket to look to. If, on the other hand, you were doing it because you were concerned about genetic issues and the like, but though that didn't turn out, then you don't have a claim. That's the way I would read the majority, is you haven't suffered any loss. Frankly, you've got a real benefit here that you didn't expect to get. But so anything goes up to 22, whatever your number is?
26 now.
26?
36. 55?
And you would even tell me that that means college?
Yes.
Yes.
No, I mean, no one thinks that bill is getting a little excessive? And by the way, you then have to pay for the credit. The offsetting credit. You've got something of value, haven't you? I mean, those of us that have children, they enrich our lives, don't they? Well, let me ask that. How much would you sell one of your children for? Well, that's one way we could figure out what they're worth. Is there a number at which you would sell your child? Is that because they are priceless? Well, because the doctor gets a credit, right? It's not all a minus, isn't it? Is it? And because we're going to value that. You valued everything else. You put all your numbers in the front end. I get an offsetting credit. Does the case say that there should be a credit? And by the way, doesn't simple contract law talk about some type of offsetting value? You got something you didn't want, but it has some value. Okay, let's figure it out. Why are you peering over your eyes at me with that scolding look on your face?
I have no scolding look. It's my natural.
You were looking like, are you kidding me again?
I don't think you can compare the intrinsic value of a human being to the actual daily cost of living. And I think it's very fair. In fact, I would suggest that capping it off at adulthood doesn't even capture the unending obligations of parenthood. For the rest of their lives, they're now going to have 4 children instead of 3. Kid becomes disabled at 27, formerly economically independent, they're probably coming home. And this is your financial thing that you're locked into, even though you took an extra measure and were reassured by a professional. Why shouldn't they have to pay until the child is an adult? Makes perfect sense to me.
You're only locked in, first of all, because you didn't accept Al's alternative to mitigate your damages and give this child to someone who would really love it and value the child. The second point I want to make with respect to yours, we can't value the credit because somehow this intrinsic gift of human life is priceless. But we can make you pay for that priceless gift. We can make you pay all the cost of rearing that priceless gift, but there's no offsetting credit. None whatsoever for the value that child brings to enrich your life. How is that possible?
I have the solution. I think the doctor should adopt this child because he's paying for it anyway.
Well,
Paying for the child.
but I'm not sure you don't. There's got to be a credit. $50 a day? I mean, when the kids were little, going home, oh, it's like, geez, you were king, right? All of a sudden, you're home. What a feeling. Now it's only my little dog Fritz. So that doesn't. Yes, they're a lot of work. Yes, they come home. But don't they make your life? Those that choose to have children, I think they would tell you, they feel like they enrich their lives.
What happens instead be a doctor, the child it's a criminal, so you suffer for that too. So,
That's part of the, no doubt it's part of the package, those late night calls and Dad, damn it. But wait a minute though, because I think I should be getting some type of credit here, and I think you've got to tell me how to value that, because There's no way that this is all, so what we're saying is that having children is a net huge negative. There is no corresponding value to it whatsoever.
No, I don't agree.
I don't agree with it either. This is Karen's point. Could that really be possible?
Well, that's not a restatement of my point.
I think it's pretty close to it, because either it's that, or as I first heard it, it was the gift. It's such a valuable gift, we can't put a number on it.
Exactly.
So,
I
but
mean, there's nothing I could think to compare that to. I mean, how do you do that?
well, but we value lost lives all the time. So why can't we value the life? I mean, at the minimum, we could look at what the adoption agencies charge for fees and all of that, just to at least place a sort of a raw figure on that economic value of the child. We could do this, right? There are means of calculating what the worth of that healthy child is on the market.
And yet all the value of the children that we love so much doesn't pay for any of their bills in real daily life.
No, but you should have a credit to offset that. Okay, you didn't get that new BMW I promised you, but that Lexus that you did get is valuable. So let's offset what you should have got versus what you got. You got something. Why can't you value it now when you could value the damage that caused you? Go ahead.
Well, you don't offer offsets in wrongful death cases. Wrongful death formulas include, medical and funeral, earnings, benefits, inheritance, survivor's loss, care protection, love society, companionship, etc. But like, say my husband gets killed, I sue, wrongful death, it was a wrongful death situation. I don't have to take an offset if he was a real jerk and he beat me.
Oh, I think you do. I think you do. There was cases, we thought we read it, well, in evidence, there's a piece there in a will. It's in the will it says, and to my husband, I leave nothing to the filthy pig who did nothing but minimize my existence and brutalize me throughout the course of my miserable 25 years of marriage. That's what she said in the will. And he's suing for the emotional distress and the loss of this valuable relationship with his loved one. And the question was, is that in her will, is that admissible with respect to the relationship, the value of the relationship that's lost? Why wouldn't it be? Well, I mean, you've got hearsay issues, but we can get it in. Why wouldn't it be? You were telling us you had this wonderful, irreplaceable relationship. Not so much. No, right? It's in the. I'll find it for you if you want, but wouldn't you say that would be relevant evidence as to the economic loss you suffered as a result of that relationship or the wrongful death? There's no doubt. And trust me, if you think someone's going to pay you 7 or 8 figures, and you're telling us what a wonderful sex life you had with your partner for all these years, and you know what? There's another one of them. Okay, that's what you said. We got about 4 other guys here who said, yeah, she had maybe with you, but with a lot of other people too. And is that relevant on the loss of your relationship? So we do figure out what the true value is, and I'm not sure I'm in agreement that we can say what the true value of your loss is without any offsetting credit for what the value that child brings to your life. $50 a day? 10? Nothing? You pay $2,000 for a dog now. But we can't. That child it can't be valued under any set of criteria.
I don't think it was in.
Go ahead.
It's kind of strange, but I don't think it's in the negotiation, this kind of value that you are creating. about having a child. You know, you talk to the doctor, there was no conversation about the value, the emotional value of the kid.
Yeah, but there
part of
is
the
one, isn't there? Is there no value to having children? Is that what you're saying? None?
Well, you're just talking financial value.
I'm saying a value, and then we'll figure out whether we can monetize it. That's what we do for damages all the time.
Does anybody agree with the dissent in this case?
Well, I want to get there. Well, let's get there because I have a couple, more than a couple questions on the dissent as well. And by the way, so we're saying healthy children would be valued at a higher rate than non-healthy children?
We're not saying that.
I know that.
Well, I'm asking you.
I've heard that before.
I would say that.
You would say that.
Well, a healthy person struck down in his prime is valued more than an unhealthy person struck down in his prime.
Looking
Well,
at the financial.
you guys can make faces at me, but this is the problem that you have made when you have decided, against my policy urgings, that this is bad public policy, okay? Because now we've got to value, so you're saying sick kids aren't worth as much as healthy kids on that credit. And by the way, there's one of these cases, I didn't bring it up the other day, but there's one of these cases, these two women out in Chicago had a baby by IVF, and heavens forbid, the baby was black. And they said, we paid for a white baby.
Oh, that would be $1. Oh my goodness.
No, you can, and they got crucified for it, but but you can look this up. And they brought suit. They said, we wanted a white baby. And this baby's not white, and therefore we didn't get what we bargained for. Someone should pay.
Yeah, but wouldn't that be the same? Wouldn't that be the same thing if you went to? I'm assuming they went to a sperm bank.
Yep.
So if you picked sperm specifically for one person, mixed it up and gave you someone else, it'd be the same argument.
Is it?
I wanted this.
I wanted that high-achieving SAT score, and look, you gave me the friggin' mechanics kit.
Yeah, but isn't
Is that, no, that's the way this goes? So now you're going to make it all like a warranty breach of contract claim? That's all this is? This is not a med school prodigy. This is not. And because by the way, those of us again that have kids, if you have really, listen, we all have high expectations, but let's be honest, we're going to be disappointed along the way, aren't we? So, but all of a sudden now, this isn't science. This is some type of exact system that everything's going to be great. That you shouldn't have to expect, when we're talking about human life, any variation in what could or couldn't happen. And so I want to get to Al's point. Hold on, there was another.
But if you look at it from a strictly contract point of view, then it's a breach of contract.
Oh, okay, hold on. Look at the bottom of page 772, and I'll get to a minute. We conclude that in addition to the recoverable damages described earlier in this opinion, parents may recover the cost of rearing a normal, healthy, and they're making a distinction between healthy and unhealthy. But don't blame them, because this is your policy that it's okay to bring this type of action anyway, despite the damage it might do to little Johnny as he gets older, sitting in law school and reading and say, hey, that's my mother. And then it says, may recover the cost of rearing a normally healthy, but at least initially unwanted child if their reason for seeking sterilization was founded on economic or financial considerations. In such a situation, the trier of fact should offset against the cost of rearing the child the benefit, if any, the parents receive and will receive from having their child. I get a credit.
That's the dissenting opinion?
No, that's the majority opinion, 772. I get a credit. So now we just have to value what that credit is. And so I guess I'd start with the same question. How much would you sell one of your children to me for? Because that's at the minimum what the credit is. It is, isn't it? How much are they worth on a daily basis when they bring pleasure to your life? $10 a day? That's not a lot. $10?
It's different if they're a doctor or a mechanic.
Is it really? I mean, I did that in a bad way because they might be a lot happier, one as opposed to the other, and we're not sure which one. So it says, we discern no reason founded on sound to immunize a physician for having to pay. They agree with you, but they say I'm getting a credit. And I'm not sure why they didn't talk about, and what's the credit? $20,000 a year?
Well, if you can't come up with one, they offset and then you got nothing.
Good by me. There should be a credit. Okay, listen, I've got to ask you about the dissent. Al wanted to go here too. Okay, look at the dissent, because I've got another very non-PC question to ask you. O'Connor, Nolan, and Lynch. 3 good Catholic guys. No, but this, honestly, this is my real question. And by the way, Justice Lynch he was a salt of the earth. He used to be a trustee of the law school before his death. Great guy. And Nolan had 8 kids. Okay, we appeared before him one time. He's a funny guy too. 8 kids. Okay, and this is my question for real. Do you think their religious upbringing and their background, at least in part, reflects their thinking in this dissent?
Yeah,
Yes.
Yes. A couple of Irish guys, yeah.
Is that okay or not? I mean, do we accept that there is? We may like to think that the law is separate from religion and all the rest of it, but is it? Is what I'm asking you. I mean, is this something that? Well, I guess I will go all the way with it. So is that something we play depending on who we appear before, their own personal influences over the course of which has to consider how religion might have influenced them as well? Because don't you think first of all that that's not a coincidence that these are 3 Irish Catholic judges who probably over time the church influenced their thinking in significant ways. I mean, it's about the birth of a child, and Catholic teachings on all of this. Is that what do you think about that? Is that saying, oh, I don't know, that's a little too close for me?
Well, from the attorney standpoint, if you're representing one party, you know there are 3 Catholic judges, so you try to.
So you're going to play that card?
You have to play. You have to do what you have to do in order to win the case.
You all agree? Or do you think? Does anyone? Do you not think that somehow their background played a part in them joining together for the dissent? I mean, look, the creation of new human life. I mean, look at the language they use here as they reject what the majority. Look at. I disagree. The state's interest in strengthening and encouraging family life for the protection and care of children is legitimate and strong. I mean. Go ahead.
But the other day we talked about researching the background of the judges, how they ruled previous cases, do a Google search, different types of ways to look at how a judge might rule.
So you're going to play the religion card? You're going to play that subtle, likely unstated card that's in the room here? Because don't you think their background influenced their dissent here?
Yes.
No, we want nothing to do with this. This is just wrong, morally wrong. I read it as them saying that. This is just wrong. Tort law finds its source in social values and ought to promote appropriate public policies. They think this is just bad business. Is that partly because of all the years those nuns abusing them and beating them? I mean abusing them, sort of the way they abused us, not. Yeah. Okay, well, you can think about that if you don't want to wade in. Let's do Mark versus Khan, because here's another one. And here's the other thing that I need you to realize. You can go in the probate situation, you can go to court for virtually anything. You know, there are times where you'd sit in court and say, oh, okay. You'd write a motion up on anything. And so you can ask the court, and they may have the latitude to do just about anything as long as there's some support for it. Because I guess I'm wondering about this case. So a few years from now, if my marriage didn't work out, my wife could change the kids' names over my objection? The hell? So all of a sudden they're not coins anymore, they're Condorellis? That's the way that the court could do that? Because I could see some people doing that for spite. Right? So the court could do that though, because that's what they want to do here, is change the names of the children. And that would be okay? The court has the power to
It has to be in the best interest of the children.
So as long as the court would somehow determine that it's in the best interest of the children, those kids could be Poughkeepsie tomorrow.
Yeah, but they're gonna reach a certain age where they should have a right to say what they want.
You would think, wouldn't you?
Yeah.
So at some point we'll listen to them, but we don't always have to listen to them. And by the way, does it make a difference whether the person is paying their support and all the rest?
It does it.
It doesn't. Is that what you said?
I don't think it should.
I think it apparently does, they reference it.
Huh? They did reference that he's up to date on his payments and all of that. But that seems so, and I know, you know, practically I'm sure they do, but geez, that, you know, sometimes there are reasons why I can't, and it almost doesn't seem like that those should be intertwined like that. If I'm...
I don't think they, is it, okay. I thought I read a case in juvenile law that said, like, even if the father's in arrear of all his child support, he still can't be stripped of his parental rights without basically without cause.
Oh, yeah, no, that's fair, Nick. It should, listen, finances,
It has nothing to do with
visitation, and name changes, and all the rest, they shouldn't be wedded together. I think at some point the court does take it as involvement in the children's life, right? If you want to argue that you're involved in them and you're the father figure, well, then you need to take that responsibility. And I do think the court, because they talk about the financial orders here and what's going on, and so they do, I think, carefully try to scrutinize what the origins of this are, but I think they also are using some of that to say, well, you know, he is active here. He's not like divorced from the children's upbringing, and he should have some say over what goes on here. But I think, as Gifty said, at the end of the day, it's up to the court to make that determination of what's in the best interest of the child. And if they decide that they're going to be the Brady Bunch, the court can change the names even over the contributing father's rights. And again, it gives the probate court that vast amount of latitude to be able to decide what's in the best interest of the children, and that will ultimately control. Knighton versus Knighton. So, can I go get an injunction to prevent my wife from stepping out on me? Is that because there's no adequate remedy at law? And Mrs. Knighton wants the big lug home. But he's found a paramour and he doesn't necessarily want to come home. Can the probate court issue an injunction to prevent the alienation of affections as she sees here? Because, I mean, her husband is, as it says here, been for a long time living in adultery, and now he, being just simply a weak man, is wholly unable to extricate himself from the subtle entanglement of Mrs. Meadows' charms. Isn't that nice? They wrote a lot nicer back then, didn't they? So can she get an injunction to prevent her husband and this woman from being together? Huh? What do you say?
Well, they were separated.
But they were separated, but they were not divorced, right? And she had filed a request for separate support. I'm not sure that's the determining factor here. What is it?
No,
Why not?
because you can't put an injunction on two people in this relationship.
Why not? In order to get an injunction, what must you show? No adequate remedy at law, right? There is an adequate remedy at law here. What is it? What should he be charged with? Adultery, right? That's a criminal offense. That's a remedy at law. There's language in here, and that's why it's still here, is because I wanted you to see it, and this is historically from equity. Equity will not normally enjoin the commission of a crime. Because the reason we don't is because there is an adequate remedy at law, and that would be to try and seek the authorities to undertake a criminal proceeding. And so here she has remedies, and frankly, as a practical matter, if he's going to go, he's going to go. This is not, I mean, I guess we could get an order to enforce him to stay out, to stay away, but as a practical matter, this is going to be pretty difficult to do. Since they won't enjoin the commission of a crime, he's got remedies here, and that remedy, or she's got remedies, and that remedy is going to be seek the authorities to be able to undertake an adultery charge. So let me ask you about an order, a related order then. So Mrs. Coyne and I are having difficulties where it's being divorced. Can she get an order from the probate court to say no unrelated females overnight in the house, my house?
No, in the house, yes.
She in the house, yes.
And no, because that's her house too.
No, my house, my apartment. No, she can't do that because of this case. She says I don't want my children exposed to that.
If you're divorced,
Kids
right?
live with you, then they're one different.
Well, the kids are there on occasion, right? You've got visitation and the like. So could you get an order? Could she get an order like that?
Yeah, well, it
When
doesn't
the
feel
kids-
like.
While the kids are there, no overnight unrelated females in the house. What about for not even overnight? No unrelated females in the company of my children.
That's unreasonable.
Is it? No. Because they're young, they won't understand what's going on. We're just getting divorced.
I have it in my custody agreement.
Okay, there you go. She has it in her custody
He
agreement.
sleeps in the same room as him. There's no females allowed unless he wants to give him his own room and split it up and make it
What do you think of that?
less inappropriate, then, yeah, but it's in my agreement that while the situation is the way that it is, there are no females allowed to sleep in the same room as my son.
So she's regulating the sexual activity of her ex-husband. Like Mrs.
No, you only have
like-
every other weekend,
like-
do whatever you want, Humphrey.
No, but like Mrs. Knight.
And it was nothing my husband, but I just
Oh.
put it in my
So,
agreement. that-
okay.
Not in front of my kid in the same room. You cannot have a woman sleep in the
So she can. So, women, are you comfortable with that? So now we can get an order from the probate court that regulates my activity, an adult's activity with another adult. And the reason is
When the child is there.
Child's best interest.
child's best interest. Again, this is the cloak everything in the probate court goes under. And if you put it under that, then despite what Knighton says and the rest of it, and you know, there is legitimate reasons. I'm not trying to dismiss it. And especially during the pendency of those cases, there's all sorts of emotional issues that are attendant as well. And some of the articles talk a little bit about this. I mean, you know, you're oftentimes handling these cases, you're as much a counselor as a lawyer. But legitimately, there are issues that we can not expose the children to that make it a lot simpler. So even though this case, in this case, I mean, you can't enjoin the commission of a crime, but probate court has broad authority there to decide what to do with respect to what's in the best interest of the child. And they will issue orders along those lines, as Ally pointed out as I was describing to you, all the time. depending on how it's phrased with respect to being the best interest of the child. And even when there would be additional rooms available, the fact is, especially during the pendency of the case, the likelihood, if the children are young, of having, overnight unrelated females while the case is pending, not uncommon at all for the court to issue orders saying, let's let the kids sort this out, you people sort it out, let's get you in a situation where there's both custody and everything's all squared away, and then you can move on and figure out how to deal with the emotional train wreck that might still be there and the like. One last set of cases, and that's Edgar versus Edgar. And this, what I wanted you to see is with respect to the contempt in the probate court and how that works and what the authority is. And it's important to understand that the probate court, or an injunction, period, but an order from the court carries with it the threat of contempt. And the threat of contempt can either be civil or criminal contempt, as these cases indicated, the first Edgar case indicated. And depending on whether it is civil or criminal contempt that's sought is a different remedy, and there's different procedural safeguards. Obviously, if you're seeking criminal contempt, then you're seeking to vindicate the court's authority and not, in essence, coerce compliance. In a civil contempt situation, oftentimes the idea is to coerce compliance, to bring your child support current, to get you to comply with the court order. But at some point, if that fails, then the court can turn and call it criminal contempt, where you can be jailed, not for non-payment, but for violation of the court order. And if it's criminal contempt, and he did get sufficient notice here, then he gets the right to counsel, he gets the higher standard of proof, but in return for those things, he can be jailed for a specific sentence because he is in contempt of court for willful failure to comply with the order. But obviously, if it's a financial order, he's got to have the ability to comply with the order to be in contempt of it. So, and the right of a jury trial here. So I thought both the Edgar cases are interesting simply because they lay out for you that this is one of these examples where a civil case can in fact turn into a criminal case because of the failure to comply with the outstanding orders of the court. And the other part of this where it becomes relevant is that in a injunction setting, one of the remedies for the violation of the injunction is also contempt. And it can either be civil or criminal for the violation of that order. Because again, it is a court order to do certain things. And your failure to do so, when you have the ability to comply, constitutes contempt, and it could in fact be criminal contempt. So this goes through the types of protections that he would be entitled to get had it gone, as it went to a criminal trial. While he doesn't necessarily get the right to a jury trial where the penalty is 6 months or less, it also points out that at the time he never demanded the right to a jury trial. And that's the last thing I want to say about the first case, is that you want something, you must demand it at the trial court level. I've talked to you before about this from the standpoint of evidence. And if you don't expect the appeals court to take you off the hook if you didn't protect your rights procedurally. And then lastly, the second Edgar case is now gone up on appeal. And the other thing to think about, as the second case makes clear, is one of the remedies for contempt is the cost of having to bring that action. What that means is attorney's fees. So the court has the authority in a contempt situation, civil or criminal, to also award attorney's fees because the person had to bring that action to remedy the violation that you caused. Under those circumstances, I'm also entitled to attorney's fees. And here, they're also entitled to attorney's fees at the appellate level because the court felt it was an appeal that shouldn't have been taken. So not only are you going to pay attorney's fees at the trial court level to the other side, you're going to pay attorney's fees at the appellate level as well. And the court has the power to award reasonable attorney's fees and expenses because she had to initiate and prosecute the complaint for contempt. So it actually is a significant expense if you have to initiate those contempt proceedings, and the court has the power, and oftentimes will, require the non-obeying party then to compensate the person for their attorney's fees as well for having to have brought it. So, and we see a lot of contempts in the probate court, and usually it's for child support and the like, but it's not always. Sometimes it's visitation. There are other issues that oftentimes, too oftentimes, the parties don't fully comply with. Questions on our grouping of family law remedy cases? You've got the complaint that you're going to file, you're going to prepare. All that information is online Thursday, and I will see you next week then. Okay, questions?
It has to be submitted Thursday?
You should, you want to submit it Friday or before we meet again, that's fine, but it's not intended, it's intended to replace the class, so don't spend a lot of time, researching it and writing it. The idea is to take some of your Civ Pro and this and put pen to paper so that when someone does actually pay you to do that, you have an additional familiarity with how that works. Okay? I'll see you next time. Yep.
Complaint about what?
It's a complaint for, well, you'll see it. It's for